So we started this conference with a brief talk by Susan on how research in DMs is different from research in EMs. And two basic problems were highlighted about how one is a problem with quality of data sources, and the second is the quality of institutions. And my paper really exemplifies the second point because we are talking about regulatory governance here. We are talking about the quality of our regulatory institutions. Now, in DMs, it is almost taken for granted that when a regulator issues delegated legislation, a public consultation process would have been conducted, some comments would have been taken into account, and the comments which have not been taken into account, there will be a reason given for why they were not taken into account. So, I have a lot of fun going through the website of SEC generally in life. So once I was going through the website of SEC, and I think it was a year ago, when I came across a regulation issued by SEC, which proposed strengthening the technological requirements of some market participants in the securities markets, and it proposed regulatory oversight, enhanced regulatory oversight of technology infrastructure that market participants used. And the text of the regulation was really just 12 pages. The press release accompanying it ran into 200 pages. The first 189 pages were just responding to public inputs on the proposed regulation. We don't see that in EMs. We definitely don't see that in India. And we don't consistently see that amongst the different regulators in India. So what does my paper do? It basically identifies that what are the hallmarks, what are the benchmarks of a good consultation process. We ask the question that are Indian regulators really responsive? We try to measure the extent to which they are responsive. And then we try to explain why we see that some Indian regulators happen to be more responsive than others. Now, responsiveness in global academic literature has been viewed very widely to mean responsiveness in the exercise of executive functions and responsiveness in the exercise of quasi-judicial functions. We have focused our paper on responsiveness in the context of quasi-legislative functions, simply because the data on that is the easiest to obtain, and it is a problem in India. So, there are two stories for why we wrote this paper, and the formal story is up on the screen. But I really want to tell you the informal story, the real story why we wrote this paper. In December 2015, our securities regulator issued a couple of discussion papers. One of them was a proposed regulation on protection of minority shareholders. The other was on treatment of convertible securities once they get listed. And we got really excited. So we put together a team of people, and we spent, I think, close to 4 to 5 man days doing a cross-country analysis of the subject and how it should be treated in India. And we responded to SEBI. We sent in a nice comprehensive response. After about a month, we saw the final regulation issued, and the text of the final regulation was identical to the text of the discussion paper. So we were really surprised, actually not so surprised, but we were, that exasperation really motivated us to write this paper. And yeah, of course, there is no other paper which really measures the extent to which Indian regulators are responsive, and that curiosity also prompted us. So how have we gone about this measurement? We've used two measures of responsiveness. We've used rule-based measures and outcome-based measures. What are rule-based measures? Basically, the rules or the laws which govern the regulators, whether they mandate some form of responsiveness, whether they mandate regulators to hold a public consultation process, that is the rule-based measure that we're talking about here. And what we see is that while some laws mandate some sort of responsiveness or some form of public consultation process, a lot of the laws do not. And most of the laws which do mandate some form of responsiveness are laws governing infrastructure regulators. So you'll see typically in the case of electricity regulator, the airport economic regulatory authority, telecom regulatory authority, etc. None of the laws governing financial sector regulators really mandate responsiveness in any form. And even amongst the laws which do mandate responsiveness, the mandate is vague. So it's worded as, regulators should be transparent, etc. So that is the variation that we see in our rule-based measures. We also tried to measure responsiveness through outcome-based measures. What do I mean by outcome-based measures? What is the quality of the consultation process that is actually conducted by the regulator? And how did we go about measuring that? Like I said, we developed an index of benchmarks of a good consultation process by actually surveying cross-country consultation processes. What are the kind of consultation processes that, for example, Australian regulators conduct, American regulators conduct, or EU? And of course, there's a lot of general literature on what are the hallmarks of a good consultation process. We consolidated them into an index, and we tried to devise quantifiable outputs for each benchmark, something that can be answered in, have you done this or have you not done this? Yes or no answers. And we tried to assign scores, equal scores for each output. So if the answer is yes, you get a 1. If the answer is no, you get a 0. If the answer is such that it can be only answered in proportion, you get a proportionate score. And we applied this framework to 4 regulators in India, 2 from the financial sector and 2 from the infrastructure. So we applied it to the securities regulator, we applied it to our central bank, who is also our banking regulator, and we applied it to our airport economic regulatory authority, which is really the tariff setting regulator for airports, and the telecom regulator. So just to give you an idea, flavor of what kind of benchmarks we used, fairly basic stuff. Does the regulator conduct a public consultation process? Can be answered in yes or no. Does the regulator proactively communicate with groups that are most vulnerable, or most likely to be affected by the proposed regulation? Does the regulator publish the comments that were received? Does it respond to the comments? So these are fairly standardized benchmarks across the world. What did we find? So before I go to my key findings, I just wanted to say one thing, that the way we've collected this data, the primary data, is we've gone into the website of each of these regulatory authorities. We've tried to dig into the archives. And we've gone through each and every delegated legislative instrument that they have issued for the period January 1st, 2015 to April 2016. And we find that each of these regulators issues a wide variety of legislative instruments. So you'll see regulations, you'll see circulars, orders, guidelines, all of which are intended to have an equally binding effect. Now, what we see is that the reason why I've highlighted regulations in red is because actually that is the only instrument which really undergoes some form of parliamentary scrutiny. The others are pure, I could say, executive, they're issued as if they were executive instruments. They do not go any form of parliamentary scrutiny. So what did we find? We find that even here, you can see a lot of variation, right? So about 46% of the instruments issued by the telecom regulator underwent some form of parliamentary scrutiny, whereas for the central bank, the banking regulator, it was close to 4%. What else we found? Our second key finding was how many of the instruments issued by regulators during this 2-year period really underwent some form of public consultation process. Huge variation here. We found that whilst the 10% of the instruments issued by the securities regulator underwent some form of public consultation process. For the airport regulator, it was about 41%, and for the telecom regulator, it was really high at 56%. For the central bank, again, pretty low at about 1.5%, to be generous. All right. Okay, so now then we went on to compute the final scores, and we applied the whole index. And as you can see, except for the first question, every other output is answerable in a yes or no answer. And when we add up the final, again, fairly standard benchmarks, does the agency publish comments received? Does it respond to comments received? Does the agency provide more than one form of consultation process so that the people who are responding can respond to each other as opposed to just responding to the regulator's first move? And the scores are right here for you to see. Again, considerable variation. On a score of 10, we can see that the telecom regulator achieves close to half the score, and the others do not fare so well. I would have zoomed into a couple of outputs that I think are important. One is how much time do regulators give to respond to comments? The average is lesser than 30. And if you see the world standards, at least 30 days are given before before the consultation process closes. The telecom regulator does give time for counter comments, but we've accounted for that in the main index. And yeah, this is another one. Now, this does not form part of our index because it is not a part of the consultation exercise. But the time lag between the closure of the consultation process and the issuance of the final regulation, the average time lag, there's a huge variation there, and in some cases, it is more than 3 years. So many a times, what happens is that a discussion paper is issued, and the regulator leaves it there. We don't know what's happening on the subject. And then suddenly, after a considerable lapse of time, you will see the final regulation having been issued. The consultation process was done, so the box is ticked. But you know what? The facts on the ground have changed a lot, and therefore there may be a case for a revised consultation process as well. So just to quickly summarize the findings of our paper, when global benchmarks are used and they're suitably quantified, they can actually allow us to measure the extent to which regulators are responsive in the performance of their functions. We've tried it, and these were our results. We find that in India, infrastructure regulators fare relatively better than financial sector regulators. And there is a strong correlation between the rule-based measures and the outcome-based measures. So whilst the laws governing infrastructure regulators provided for transparency, and therefore it's arguable that they fared relatively better, the laws governing financial sector regulators did not contain any such mandate, however vague, and that could be a potential argument for why they do not fare better. And the policy implications are that if we are able to develop such a benchmark index for each of the functions of each of the regulators, then it feeds into the parliamentary oversight mechanisms. The parliament can assess the performance of regulators better. And secondly, it also has implications for the way we should be thinking about changing our laws to make our regulators work better. Thank you.
Thanks, Bhargavi.